Afternoon. We're going to go ahead and start the Hearing Aid Dispensers Committee meeting. We will begin with a roll call. I'll ask each member to state their name, location, and address, and if there's anyone from the board or the public with them at that location. Start with myself, Todd Borges, Committee Chair, Hearing Aid Dispenser. I am here at the board office, 1601 Response Road, Suite 260, and there are no members of the public present. Dr. Sanders?
I'm Dr. Charlie Sanders, and I am also at the Response Road location.
Dr. Chambers?
Tamara Chambers, otolaryngologist, public member. I'm here at the Galeras Family Education Center at 427 West Carroll Avenue, Room 2, Glendora, California, 91741.
Dr. White?
Amy White, audiologist, also at the board office on Response Road.
And just to announce, we have board staff in the office here at Response Road. We have myself, Sharice Burns, Executive Officer, Maria Lorenzo, Legislation and Regulation Analyst, and then we have board counsel who I'll let introduce themselves.
Yuping Lin, board counsel.
Grace Arupo Rodriguez, acting regulatory counsel.
Can I just update to mention that Gilda Dominguez is here with me? Tamara Chambers.
Thank you. First item on the agenda is public comment for items not on the agenda. If the moderator will please open public comment on WebEx.
All right, we are taking public comment for agenda item 2, items not on the agenda. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users, dial *3 to raise your hand. And for our mobile device users, you may need to hit the ellipses button, that's the ... and cycle through the 3 different pages in order to find your hand. People will be given 3 minutes to speak, and I'll give you a 30-second warning before your time expires. We're going to take just a few more seconds now to see if we have a request for public comment. Seeing no public comment on WebEx, do you wish to continue?
Please, thank you. Yes, please, thank you. Oh. Good. Okay. So first item on the agenda is discussion and possible action regarding post-fitting counseling and foreign body in the ear canal as stated in Business and Professions Code sections 2538.11, 2538.36, and 2539.6, and Title 16 California Code of Regulations sections 1399.125 and 1399.126. I'll ask Ms. Lorenzo to present the agenda item.
Thank you, Mr. Borges. On December 1st, 2023, the Hearing Aid Dispensing Committee delegated to committee members to work with staff to draft regulatory text that would define the terms post-fitting counseling as used in Business and Profession Code section 2538.11 and foreign body as used in Business and Profession Code sections 2538.36 and 2539.6, and permit hearing aid dispensers and dispensing audiologists to remove hearing aid domes. This is in response to an inquiry that the board received in July 22nd, asking whether there is any statutory or regulatory language that would restrict a hearing aid dispenser from performing a dome removal if appropriate training is provided and appropriate safeguards and policies are in place to limit dome removal to lower risk clients. The committee met on December 5th, 2024 to review and discuss the draft regulatory text. The following changes were made to the text from the last meeting. We amended CCR section 1399.125A to specify the removal of hearing aid dome is from the ear canal or earlobe. Section 1399.125B to remove reference and applicability to dispensing audiologists. Section 1399.125B1 to specify that written verification must be signed rename the American Board of Otolaryngology to include head and neck surgery, and remove reference or applicability to dispensing audiologists. Amend 1399.25B to change the minimum number of supervised hearing domes to 5 and require the supervision be from an otolaryngologist certified by the American Board of Otolaryngology, head, neck surgery, or licensed audiologist. We also amended 1399.125B3 to remove requirement that the hearing aid dome must be visible without an otoscope inspection and within the first bend of the ear, leaving only the requirement that a hearing aid dome be before the second bend of the ear to be eligible for removal. Also 1399.125B4 to D and 1399.125D, and amended to prohibit hearing aid dispensers and dispensing audiologists from removing a hearing dome if the patient has contradiction. Rename the American Board of Otolaryngology to include head and neck surgery and include other signs of infection as contraindication. And we also amended 1399.125 to reflect that a dispensing audiologist cannot remove a hearing aid dome unless it is before the second bend of the ear canal. We do have a question regarding 1399.126. And we were wondering if it was raised at the last question about revising it. So it's a little clearer. It may be confusing. The items listed were not considered as foreign body and could raise a clarity issue. So we do have proposed language of what the language could include. So that's more clear of the differences so that the list doesn't get confused as people are reading it. And we asked the committee to review and discuss the provided materials and make any necessary changes.
Okay, thank you very much. So basically you're wanting to essentially add in this more detailed definition.
Yes, because I believe if you look at we have both the language from before
Right.
and after, and it was saying a foreign body means an organic or non-organic object or material that is not a natural part of the human body that would normally be present in the ear canal or earlobe. A complete and intact hearing aid or dome of a hearing aid present in the client is not considered a foreign body. And the question was that technically a hearing aid and a dome are a foreign object in a body, so it's not quite, logically doesn't make sense.
There was
An acceptable foreign body?
The concern was the Office of Administrative Law would have the concern,
Right.
Yeah.
generic clarity problem, so.
Okay.
So we proposed that we define what foreign body is, and then under it lists kind of restrictions or clarification and things like that. So what the language that we're proposing is the first one would specify that it's not to prevent anyone from doing these other services, such as like an intact hearing aid, earmo impressions, or the removal of dome, adding that to the list. 2 is regarding not construing this as a restriction for people who are licensed under a different practice to also do the same activities. So we're, and that's again, audiologists and ENTs. And then the last one has the, in order to remove it, you must comply with the requirements that we're proposing in 1399.125.
Okay. I have some other questions about other stuff, but let's do with this first since it's in front of us. Does anyone have any questions about this? Any concerns with the way it's written?
I've never found a foreign body in someone's earlobe.
Right.
Thank you.
How to say?
I didn't
This is
understand
the
the
earlobe.
earlobe as I understand it. This is an
But
earlobe.
a con-
In which
all of
case-
it's in a-
We're gonna be removing earrings.
Yeah, we could change that.
Yeah, earrings in that regard.
So that, the
Yeah.
earrings are the only thing that's there, that.
Thank you.
As you can tell, we're just staff. Not sure.
I kind of wondered, I was trying to think where that came from, if someone had mentioned that in our discussion.
I wonder if it was talking about the bowl of the ear.
I think
And
it's
then it
talking
was
about tonsils.
misconstrued
Right.
as
well,
the ear.
Gotcha, yeah, okay.
And so the question, I guess, then is, does anyone feel that we need to specify ear canal or bowl of the ear, or can we just leave it at ear canal? Because if something is in the bowl of the ear, I mean. we
It's
do do
outside of
that.
the ear, you're gonna pull it out, yeah.
And
Yeah, I think specifying ear canal is
Fine.
fine,
Okay.
Yeah.
because that's what we're talking about, it's ear canal.
Yes.
The bowl, it's there, you're gonna,
You can
they're
see
gonna
it.
grab it, the person's gonna grab it, that's not gonna,
Right,
it doesn't require any special.
removal.
Yes.
Yeah, so, and the regulations does say before the second bend, so anything before that is all.
Theoretically, it's covered.
Yeah.
So I think just leaving it at ear
But
canal.
we really don't like those earrings, because it's.
That's in a few sections that you're loading.
Yeah. I read it, I think, 3 or different times.
All right, yeah, well, that's an easy fix.
And then it also mentions intact hearing aid ear impressions dome of the hearing aid, but doesn't say anything about filters. Of whether they should or should not be allowed to do that. Little filters fall off in ear canals all the time.
With custom devices, yeah. That's something we hadn't even. Subject matter approached.
Is that something we need to specify?
I would, given this, I don't know, I mean, given the size of it, it's a little bit different trying to get that out than a dome.
Why would you remove it?
Because they're just gonna put more in.
Wouldn't it just fall out with the wax?
Not necessarily, it could get actually clogged up with the wax,
I've
but
pulled- I've
that-
pulled 5 or 6 out of some same guy.
Yeah. That being said, I think something that's that small, I think should be out of the scope of.
But we should
That
say that.
doing.
No,
No, because we're talking about dome
specifying.
removal. We're saying
Right, that's my
specifically
only
domes,
question,
yeah.
does it need to say
Yeah,
not to?
no, I think we need to keep our focus on
Yeah.
just the dome, because
Great.
Yeah, the
I
only,
totally get what you're saying, because I see that too. And, but, yeah, I mean, I just tell them to go to their doctor and have them. I don't want to go rooting around for a little thing, and that's hard to get with forceps. Any other, issues concerning this particular, discussion question?
So for clarification for administrative law, then under discussion question B, a foreign body means any blah, 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 blah. And then we add 1, 2, and 3 because we're basically giving the exemption to, because essentially we're saying, yes, they can remove a foreign body, or they cannot do foreign body removal with the exception of. So do we need to use language like with the exception of, or is having 1, 2, and 3 specific enough? We're acknowledging these are foreign bodies, so we are making an exception in those cases. Or is it okay as it?
In my thought, it just clarifies that this is not the foreign bodies that the legislation intended long ago when they were discussing what those foreign bodies would be. Because hearing aids back then didn't go into the ear.
Well, there were no domes.
There were no domes. There were no little
Right.
things that could get stuck in
Right.
there. There's that big receiver, right? So.
Right.
So I think that's the difference is we're clarifying what it means in terms now, right? So, but I would ask Greg's counsel for any input on that.
So as I'm looking at it, it is defining it, a foreign body is only 1, 2, or 3. So if you think of there's anything else that should be added, because we don't have language and OAL does frown upon saying, including but not limited to kind of things, the way it's set out, that's all that foreign body can be. So anything else is not going to be defined as foreign body. So I don't know if there's anything we should also be thinking of that we want to include here, because it is very narrow.
And that's the whole point of the wax filter, which we're excluding that by this.
By virtue of that.
Yes.
Do you
So I think that's the only thing, by limiting it to these 3, or these things that could fit the
We're
definition,
saying those are the 3 exemptions you get.
that 3 exemptions you get, yes,
Outside of that, it's a no-go.
exactly.
What about the dams? The Oda blocks? So when we go to take the ear mold impression, we put the Oda block in there. So this defines you can remove the ear impression, but it doesn't say anything. I mean, are we
I construe
assuming?
that as a part of the ear impression. The dam is a component of the ear impression.
What if the string came off? And you're like,
That's what I mean.
Well, That would be.
So now you've taken-
I've never ever literally seen that
Yeah, we had
happen
to use
in my 27 years, but yeah, I mean, it's, that to me is whether or not we have to specifically define that as a part of the impression, that's the question. Yeah, I mean, do we need to define the odo block as a part of the impression, or is that assumption legally tenable?
Because it can come up.
It's
from the
theoretically
impression.
possible, yes, it is theoretically
And I
possible.
think we should, if it's theoretically possible and that would be permitted, but then I do think we need to like.
They currently already pull these out.
Okay, so I
That's
think
part
we
of
do
their
need
scope of
to
practice,
Right.
so we should probably say it.
say that.
And does it, do you call it, is the generic term dam or is the generic term odo block, or is that a specific type?
I think of odo block, but
Can it just say all the materials used to create an ear impression, ear mold impression?
the only thing would be the odo block. There isn't anything else we use. So-
Maybe you have a blow by.
Well,
And you
but-
have silicone material now stuck down there. I mean, it'd be on the second bend,
Yeah,
so.
but
you
that's
would-
that's impression material,
So,
which
Okay.
is, when it says impression, that's a part of the ear mold impression. So that's, to my mind, that's already covered. But that was gonna be, but here's the thing though, that's gonna probably be on the second bend.
that's what I'm saying.
So we're not gonna go after that anyway.
Okay,
Because since it's anything beyond the second bend, we're not supposed to touch.
I think odo block
Or
is the
ear
more updated phrase. I think ear dam is probably an older
Yeah.
phrase.
Should
Odo block
we
to
use
work?
both though, or depending on?
No, it's one odo
Block
block
is
they
one.
shove in there and then they make sure it's in there properly and then they put the impression.
Keeps it
I was
hot
saying,
or
I was
so.
talking about the
They're
dam
two different phrases.
Phrase.
Oh,
I don't
because
think
of your
that's necessary.
practicing.
But it's
licensing.
tissue versus clean.
Yeah, yeah.
It is the name of
It
it.
is.
Yeah.
okay.
So we should probably, if it's the name of it, like, I wouldn't want to use Kleenex, I'd want to use the term that's equivalent to the generic tissue. So that's,
Okay, so what's the generic?
Wow.
An odo block
I mean,
is
I was gonna say, I always thought odo block is a generic term. I never actually considered which one might be the actual generic term. Because they're interchangeable, so I always just think odo
Yeah.
block. And I think it's understood what that is. And it covers, I mean, whether it's foam or cotton, it's an odo block.
Right.
And it doesn't matter, we could have more than one in there.
Don't capitalize it.
Singular, it doesn't.
Well, yeah, right. I mean, sometimes you have 7 or 8 of them in there.
Exactly.
can we put
I see.
odo block or the equivalent? I
I
mean,
see ear dome or ear dam.
Well, ear dome is something, different, but yeah, ear dam.
Maybe odo block is a manufacturer.
I think it's a type of
brand
ear
name?
dam.
Like brand names.
But I guess it could be.
Yeah, I think we need to use ear dam.
Okay.
yeah, odo block is the name. For
Okay.
the product.
Literally never thought of it.
It's good when the tissue conversation keeps.
Yeah.
Sorry, one name or the other.
Xerox, right?
One name or the other.
This, or their Xerox, this is
Yeah.
dated too, but.
That's helpful, though. Okay. Let's go ahead and add it right before ear.
Anyone on the committee have any more that they want to discuss concerning this one item before we open it to the public?
I was just gonna add, just maybe check for consistency. I know we say clients here. I don't know if throughout this section or the broader
It should,
codes, if clients or patient or.
it should be clients in these
Okay.
sections.
Clients with
Client or consumer,
Yeah, clients or consumers.
client or consumer, one or the other.
Okay. Just, I know that's another stickler for OAL. They're like, well, you use consumer here and you use client here. So
Right.
whatever it is, that's like a non-substantive change. So those are kind of cleanups that when we do go through the text, we'll clean those kind of
Anyone else?
things.
Yeah. Moderator? We could open up for public comment on this one item before we move forward. Public comment.
My apologies. It would help if I take care of this. We are open for public comment via WebEx on agenda item 3. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand. We will call on people in the order we have requests. We're going to take a few seconds now to see if we have a request for public comment. Seeing no request for public comment via WebEx, do you wish to continue?
Please. I have a couple of other things. On 1399.125, post-fitting counseling, the first page.
Mhm.
On 125D1, visible congenital or traumatic deformity of the ear, other signs of infection. I'm just wondering, do we need to have the term congenital there? I mean, I don't, when I'm looking at someone's ear, I don't have any clue if it's congenital or not, but I know if it's traumatic. Is that necessary to be included as a, just on that line?
I think it actually is.
Okay.
Just so that, you know, it's not traumatic. I mean, you can have somebody who comes in with like a no-show or some kind of partial ear for whatever reason, and it did not happen because of trauma, but they were born that way. So I think you do have to have some kind of.
Gotcha. Okay, I understand now what you mean. Thank you. Right, okay. That makes sense. I thought it was trying to identify the damage, which, okay. The other question is under 1399.125B. The written and signed verification by an ENT that we performed the dome removal. I started thinking is that we're limiting this to just an ENT that can sign off on this, as opposed to a GP or a pediatrician or an ER doctor. I mean, pediatricians are taking Legos and beans out of ears probably on a weekly basis, and who knows what ER doctors are taking out of ears. So I'm just wondering, it seems limiting to me that we just can go to that particular doctor in order to get signed off, when most MDs, I would say, have, experience, whether it's earwax removal with the GP or my other examples. And I'm concerned that by limiting that can make it very difficult, a real barrier to the dispenser, because if they live in a very small town, there may only be an audiologist and an ENT there, and if they don't particularly want to help them out because it's competition to their business, then they're basically stuck. Feel free to tell me why I'm wrong.
I'll tell you why you're wrong.
Okay, thank you. I knew Amy would. I wasn't sure if Charlie or Dr. Chambers would, but I knew Amy would.
I don't.
Comment.
I think what we're talking about is having someone verify that the individual is competent and well-trained to do the removal. And I think if you expand that to like a general pediatrician or a GP, and I don't know if Dr. Chambers would agree, I can't tell you the number of times I've been with my kid to a pediatrician, and I know they can't actually see their eardrums. They're not looking in the right place, or what I already looked at, they definitely haven't, they're not describing the same thing. So I don't think that a lot of general practitioners have a lot of experience working in the ear. Not as much as a dispenser or as an audiologist or as an ENT. So I would think if we're talking about verifying that it's being done safely and competently, that it would be best being done by someone who works in the ear a lot.
Well, that being said, they can certainly have a lot of experience taking things out of people's ears. And that's essentially what we're talking about, is being able to remove an object safely. And if they remove objects from the ears, why can't they then say that this person can, manage that safely as well as an audiologist?
So what if it's their MSA doing it?
Their MSA.
Their MA or medical assistant? Because I think that that's really common, you know, for a lot of physicians, they have their assistants doing lavages and earwax removal, and the physician themselves doesn't generally do it.
Right, which makes sense, but then that wouldn't be a doctor that I would go to get checked out on. I mean, if you ask, you know, you basically ask the question, who does this? Your assistant or you? And if it's the assistant, because you're right, there are a lot of GPs that don't do it. So that person would be disqualified.
But then how do we ensure that they are qualified?
No.
They're an ENT, they're qualified.
Yeah, but then I don't know. I mean, I feel like the pediatrician is qualified, whether they have their, I mean, just to backtrack on myself, whether they have their assistant do it or not, they had the training in medical school. They've done it. So,
But like Amy was saying too, I've had so many physicians send me a patient who insisted that that ear canal was clear, and it has completely impacted the cerumen.
well, yeah,
And that
I've
just
certainly seen
happens
that.
all the time. So general practitioners,
But see, I'm separating between looking in the ear and saying, oh, there's wax or not wax, and seeing an object and pulling it out. Well,
same thing.
If you can't identify,
I guess you're saying if you can't identify there's something in the ear.
Yeah, if you can't find the ear,
Yeah.
you can't find a dome.
What's your feeling on this, Dr. Chambers?
Yeah, I don't think that actually there's training on this in medical school. And the number, you know, and I don't know that people actually do it as frequently as we might think. There are a lot of times when kids end up traumatized in our ENT clinic, and they, you know, because somebody didn't know what they were doing, and now we have to manage that and kind of deal with that. And of course, there's a lot of behavioral reaction that goes with that. So I actually don't think that it's done frequently by non-otolaryngologists, and I don't think it's safe to promote so.
I don't know. My only concern about that is the fact that it's so limiting to who you can go to, that we're almost,
It's only
we're
one.
setting up a barrier that, you know, essentially we're saying you can do this, but, you know, now you can't because you can't find someone to actually check you
The
out.
job of the board is not to protect the.
I understand,
Dispensing.
I understand, but I wanna bring it, is there a possibility of other doctors being able to be brought into this other than ENTs? Is there any specialty that might have this experience that we can expand on this? If you don't think GP, sure, I get that. So I'm just person by person, whether it's a pediatrician or whatever. I'm just kind of throwing it out there because as I look at it, I kind of thought, I don't know. It just seems very limiting to say just this one doctor can say whether or not you can successfully pull a dome out of someone's ear that's at the first bend.
One example I would give, just to chime in, is that it is limiting as well for the speech language pathologist to get their flexible endoscopic evaluation of swallowing passages as well, because it does require an ENT. It doesn't allow other people to do those first 10. So part of that becomes these group trainings where they go out, probably out of town essentially, to this training, and they'll get certified on however many scopes that weekend or those days, which is way more than the 5 I think we're at now. So they would get all that done in that one little seminar and weekend. So it is limited, but they've found ways to make it work and also provide training and
Assuming that we can, that an ENT would do something like that.
You've also got audiology.
Well,
you also can have audiologists, so yeah.
I understand that, but there are some towns where there's one audiologist and the likelihood of them saying, sure, I'll check you out on something that I do, you know.
Well, hopefully,
But I
Whatever
mean, I
VP
guess that's what that
report.
person has to deal with that particular issue as it comes on. If they need to go out of town, they need to go out of town, but they gotta do what they
for the
gotta do
seminar to do it.
to get it to work. So, okay. Well, I just wanted to throw that out there because it did seem a little bit off to me.
If it's deeper than that, they probably are referring to some otolaryngologist anyway somewhere.
Well,
So I know this is not necessarily legal per se, but just suggestion for the board to consider for policy. Because I think our consumer protection hat is the foremost, right? So we also want to make sure whatever is being done is done safely and with the person that's most experienced, what have you. But at the same time, and and I think this is a policy consideration. It's also barriers. So I know just generally, because there are communities that are more rural, are we limiting the ability for certain patients to get access to whatever they need? I think so if it's more of a competition between, individuals, then that shouldn't be our worry. But if that competition does impact the ability of a patient to receive their proper care, then maybe we do think about, in certain circumstances, you expand the scope of who may do this written sign off. I'm generally aware that some boards do that when there's a limitation of who can provide in, like, say, Central California. They may not have this expertise, so there will be permitted if within, and they'll consider, looking at the licensee population, but then looking at the mileage. So they'll say, if within 100 miles from where you live, or 50 miles, or whatever you think is the most reasonable, there isn't this ability to get this sign off by this type of, EMT, then, will be permitted to seek approval from XYZ. But just wanted to put that out there because the barriers for patients to receive that care is something that, we should, the board should consider in drafting the language.
Currently, they're barred, so this would at least get some less
Okay.
barrier, but it does
I don't know
have-
if we want to tackle that on top of everything else, at least
Fair.
at this point. I think that's really getting in the weeds.
Well, and I think it's reasonable to see how it goes. And if there is a justification to reconsider, then that can be reconsidered. But I don't think, unlike I can't think of, Dr. Chambers would know better, like a real subspecialty area of medicine where there's like 3 of them in the state or something of that nature. That's not what
Right.
we're talking about. The availability of audiologists and ENTs in any given region. You could pick almost anywhere in the state, and I've been on to almost everywhere. There's multiples to choose from. So even in rural Northern California on the Oregon border, for example, we have clinics up there. So I don't think it's probably such an issue as maybe some of those other highly specialized.
Yeah, I wouldn't. I think it's kind of an all or nothing thing. Either we adopt that other doctors can, we agree that other doctors can reasonably, check someone out to remove the dome from their ear, or we just limit it and just kind of leave it at that. Okay, thank you very much. If we want to open for public comment for these 2 items. Well,
All right, we are open for public comment on the second half of agenda item 3. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users, dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take a few seconds to see if we have a request for public comment. Seeing no request for public comment, do you wish to continue?
yes, thank you. Okay, so we're going to go ahead and leave that as it stands. It sounds like everyone's in agreement leaving it as it stands. And are there any other items that someone wants to bring up on this agenda item? Anyone have any other questions or comments or concerns, language? Dr. Chambers, do you have anything?
No, thank you.
Okay. Motion or anything, do we? Because
No, we'll bring you back a clean copy for the committee to vote on next time, without earlobes.
Thank you. I was questioning that, but I thought maybe someone brought that up. I don't know. Okay, moving on to agenda item number 4, discussion regarding hearing aid dispenser trainee supervision and operations at primary and branch locations of their supervisor as stated in BPC 2538.27, 2538.28, 2538.30, 2538.33, 2538.34, 2530.35 and 2530.53 and Title 16 CCR sections 1399.114, 1399.116, 1399.117, 1399.118, and 1399.119. Welcome for reading. And Brennan, you could go ahead and present the item, please. when it starts.
Absolutely. So at the December 2024 board meeting, our wonderful chair here, Todd Borges, asked if a hearing aid dispenser trainee can do their unsupervised hours at a location other than their primary place of business, and if they need a branch license to practice at those other locations. Mr. Borges also, we missed a word there, asked whether the supervisor needs a branch license for the trainee to work there. So we wanted to provide all the statutory context for this because right now there's a lot of the statute that could use some clarification. Sometimes when it's talking about a license, it says a license means a hearing aid dispenser or a temporary or a trainee license. But in other sections, when it's talking about what address needs to be on file with the board and whether or not there's a branch license, there's a few more caveats, but we kind of need to potentially clarify those statutes, which applies to which. So in this sense, if we look down at Business and Professions Code 2538.28, the supervising dispenser is always shall be responsible for any acts or omissions committed by the trainee licensed under their supervision that may constitute a violation of this chapter. So you're always in charge of the trainee at all times, and you're always responsible for the trainee and how they deal with patients or clients and everything else. If you look at the next one, 2538.33, it talks about how a licensee, and they use licensee generally, needs to notify the board of their address or addresses where they will engage or intend to engage in the practice of fitting or selling hearing aids and any changes in the place of business. And then it talks about if it doesn't receive mail and so on and so forth. You get to the next one, 2538.34, it talks about established retail business address. You have to have one, and if you're in the state of California. And then B is where it talks about if a licensee maintains more than one place of business within the state, they shall apply for and procure a duplicate license for each branch office maintained. Now, what I pointed to is that if a licensee maintains, so it's saying you are maintaining that office, not just that you're working there, you're maintaining that office.
What is that?
So you're operating. So that's where we get to the next one, right? That skip down to 25838.30. A temporary or trainee licensee shall not be the sole proprietor of, manage, or independently operate a business that engages in the fitting of or sale of hearing aids. So when we talk about the licensee maintaining an office, and that needs to be a licensed branch office, that means you're maintaining the office. The problem I see is if you have a trainee, they're working under your license. At any of the locations, that's where they're under your license. That's what the law says. They're under your responsibility at all times, operating under your license. And that means at any of your primary or secondary locations. So your primary or any of your branches. I've also seen it come into play where I look at a location and there's only one licensee associated with it. And that person is a trainee, and that's a problem. So again, these shouldn't be locations that they are maintaining or operating because it's prohibited by that statute. So they can't, while they may not be the sole proprietor of the company, they are maintaining and independently operating that branch all by themselves.
So are you then saying that, so the dispenser, in essence, you're saying the dispenser does have to have a branch license for every place that the trainee is going to operate. So they'll both need branch licenses.
Just you at the
Just
super.
be, okay, so you're
But
saying
they're operating
they would need the
under-
license. They would need a branch license to operate because they're operating under my branch license at that location. Okay, so that answers that question. So
Back
the
in the
trainee
day, you would
does
have-
not need individual branch licenses.
Exactly.
The dispenser, who is their supervisor, needs a branch license.
And then you are
Okay.
responsible for the operations and maintenance of that office.
And that's how we did it for years at Whisper when we had 8 offices in Northern California. I had a branch office at every single one of them. And half of them I never went to. But other people also had branch office licenses at those, like Lisa and Andy had
Right.
branch office licenses for the ones in the Bay Area and mine, so that we could go to any one in the absence of another and sell a hearing aid there that needed to be sold.
Okay, but then by this definition, you're not necessarily the person maintaining that office. You're a temporary.
Well, so this is where I have a problem. I don't think we have a good definition of maintaining or
Right,
operating.
that's kind of where
Right.
that's where I'm driving at what maintaining means.
So I think Sharice just defined, or you just stated a minute ago about, it'll be a branch location and the only licensed individual there is a trainee, that there is no other person, no licensed non-trainee person that's at that branch. So one could then infer that they must be operating that independently because there is no other licensee listed as being at that location. Is that the sole way that we're determining? Otherwise, what does maintain, I sole proprietor makes sense, but manage or independently operate or maintain mean?
And that's something we should
We
probably work on.
so we were already in the proposed, we have a proposed text for hearing aid dispensers, training and temporary license where it was, that word is being defined under the supervision requirements.
So you think
That
the
that
person-
runs up against a lot of corporate locations, even smaller ones like Whisper, where, you know, you may work for Costco or Hearing Life or Whisper, someone, and you're gonna have branch licenses for multiple locations, because you may have to go there one day if someone's on vacation. Okay, but that's not my office. My main office is wherever I am, but I'm gonna go there, so my trainee, then on their one day or 2 days where they're not directly supervised, they could, if I had a branch license for this office, they could go there and work independently, because that's the unsupervised day, because I have a branch license there. Right, so that's,
Now, if it's truly temporary, you go back to 2538.34 and you can just tell the board, we get these letters all the time. I'm gonna be at this location for 2 weeks. That's it, and then it goes away, right? So we get those as well, where
Is it
they're,
really the person signing the purchase agreement and the address on that purchase agreement associated with your branch office license?
say it again.
So who's signing the purchase agreement? And what is the address on that purchase agreement? That person should have a branch office license for that address.
Unless they temporarily.
Unless it's
send
a
that.
temporary, unless it's truly a temporary, and that's not the one
not
day a
trainee,
week for the next
that's
6 to 12 to
dispensing.
18 months,
Right.
yeah. But we get them for
Is
where
that
it's like
maintained?
1 week or 2.
Is that the definition of maintaining? I'm collecting money and signing a purchase agreement.
You're there, you're ensuring the lights are on, you're ensuring things operate there, that people are getting their
Making money.
receipts.
yeah, but you see, that butts up against, you know, that's such a very
Janitor could do that.
specific definition. If I am going into this office because someone's on vacation, I'm not maintaining, you know, the lights and all the other stuff. I'm just showing up to, you
You're
know,
just a temporary.
help the consumer, right? But I'm not getting a temporary license.
No.
I have a
you just
branch
tell them.
license. I have a branch license for that.
You don't need that. If it's for 2 weeks and you're covering vacation, you go back to the temporary. You send the letter to the board,
Well,
tell us
but
where you're
most
operating.
people are getting branch licenses so they can, because they never know.
Oh. when
1
they
month
need
to the
that.
next month to another month, I might have to go there 6 months from now, or, so I'm just gonna get a branch license and pay my
Have to
$25,
go there tomorrow.
so I don't have to
Another
worry
place.
about it, right? But I'm not maintaining that office, because it's not my office, it's some other guy or gal.
But that other person's name is on those purchase agreements and then.
My name would be on the purchase agreement because I sold the hearing aid while I was there.
What does the website say on there for the location and the people at it?
Well, the location would say, it would say, I would assume, the name of the person who's there full time.
Because what I was seeing was trainees, the only person at that location, and
That's definitely a non-starter, but.
and that's where I ran into the problem that,
right.
like, obviously, things happen, right? Staff can interpret one law without the context of the other law and say,
Right.
sure, yeah, no problem, and they gave them a branch license because the other one says any licensee can get a branch. Well, no, it's not meant for any licensee, and we can fix that. Because we can go ahead and run a whole list and find out who's associated with what branches, and hey, wait, you're a trainee, sorry, but you can't have this branch, your supervisor needs to open the branch there, or register the branch, it's already open.
So the supervisor would have to get a branch license for that office, and then that would allow the trainee to work there.
Exactly.
Theoretically unsupervised, if that's part of their 20%. Right.
That sounds like kind of a couple definitions we're working on is what does it mean to maintain an office? Something we could consider is a place open for business where duties that a licensee would be subject to, you know, we could play around with what that is. And I think temporary is also key, because if it is, you know, 1 day every week versus 2 weeks, but is it one of those situations where it's 2 weeks that it's repeated how many times? So I think areas that we need to, I don't know if it's right now, but
So probably the other one, but yeah.
So yeah, what does it mean to maintain, and what definition do we want to use for temporary?
Or
Because
can we maybe not use the word maintain and come up with a better word?
Yeah, I was
we could do
gonna,
something-
I just
Well,
don't-
that's
I
in the
just-
statute,
I
so
just-
that's in
we have to use maintain.
so,
Or you have to go to the legislature and ask them.
yeah, I mean, there's a lot of, we provided the definition of some terms because I think that's where a lot of the confusion is. It's like, it's using like the word licensee to mean everyone when we're in fact talking about just hearing aid dispensers. So,
Permanent licensing.
yeah, so I mean, I recommend we could, since we do need to kind of look at it and see how those need to be fixed. We do recommend that you can change the word so that, it targets the appropriate license type, because right now it's everyone. And,
So we can clarify maintain.
Yeah,
We might have
and-
to leave the word maintain, but
But
we can
Need
clarify
more
it.
clarification.
Yeah.
Yeah, what does it mean
Yeah.
in the board's case? The other thing being, we're going up for sunset next year. So if there are these ones where it says every licensee, and what it really means is every hearing aid dispenser, we should just ask them to say that.
and then, I mean, and I also, there's also the definition of hearing aid dispenser it means a person engaged in a practice of fitting or selling hearing aid to an individual with impaired hearing. So it's just like, when the laws were written for the hearing aid, it was kind of a mixed match of language use. So that's something we'll have to clear up so that in order as for us to clean up the rest of the law. Because right now the terms are kind of just very broad in some sense.
And is temporary, regular, recurring, or is it not regular, recurring? Like,
And that also could be part of the thing is like, we need to think about this in terms of how people operate these days. And so that we are ensuring consumer protection, and we don't have a trainee who's the only person located at that place. I'm assuming that is not generally the case, and we just randomly saw it that one day the website only had that person on there. But again, like, that's what the intention is that, yeah, you as a trainee can operate under your supervisor's license and at all their locations, but you can't be the only one who that is on the website is advertised that you're practicing there.
Well, and
The only license of record.
Yeah,
What you're saying.
and that's what it was looking like.
And I think part of that will be, because like right now, where you have 16 CCR 1399.119A, and it's talking about the supervising dispenser present, but we have already discussed defining what supervision is and how much they have to be supervised. So all of that is already changing. And I think perhaps with those updates taken into account as well, that will get at the root of this idea that some people are getting trainees and just throwing them out to some place where they need a body and they're not actually getting supervised or trained properly, but because the supervision requirements are also being updated.
Well, that is covered by the supervision requirements, right? I mean, they're gonna,
Right.
as long as they're only doing that for 2 days a week,
Right,
they're within the law.
Mhm.
So,
right.
you know, so theoretically, as long as I have a branch license for this location that no one is at, because it's maybe a, it's like a temporary, like, what do we used to call it? Service center used to be the term for it, right? There it's only open a couple days a week. So then I just have that person go those 2 days a week because that's their unsupervised time.
Oh, okay.
Right. But I've got a branch license for that, so therefore it's legal.
Unfortunately, there will always be loopholes in this.
Well, I'm-
Unfortunately, but technically.
Unsupervised is unsupervised, so I mean, whether they do it in my office and I'm not there, my main office and I'm not there, or they do it at a branch office and I'm not there, it's the same result. They're
I mean,
supervised.
technically, I would tell you they're never unsupervised. They are indirectly supervised. You're
Well,
not with.
So then that's right, but then that's the definition of indirectly. What's the geographic limit for indirect?
And I think you don't usually go that far.
But that's my point, because you can stretch that definition of indirect considerably to basically cover this, because that is indirect. It's maybe, pushing the limit of it, the exact verbiage to your advantage, but that is indirect.
But I think, Todd, that's where the maintain proprietor, sole proprietor, independently operate comes in, because that example you just threw out, I have a service center that's open 2 days a week. And so I send my trainee there 2 days a week and I don't ever go there. So is the trainee the only person ever there? Now you're falling more into, okay, well, what's our definition of maintaining and operating?
Well, and
Because if they're the
that's my
only one there.
that's my exact point.
Right.
But
So
the owner operating thing, that my problem with that verbiage is that that's up against again, back to the corporations, because I'm not, if I'm an employee of a large company and it's another office that I have a branch license to, well, I'm not the, owner operator. I'm not operating that because that's operated by the company, not by me.
So do we want to
So,
tackle this definition of maintain or put a pin in it and get to it? Because I feel like it is crucial to this discussion,
Mhm.
but I don't know if we want to, put a pin in it and hit it here or kind of work.
let's see what maintain looks like and then we can come back to it.
Okay.
Dr. Chambers, would you like to weigh in on this lovely conversation?
Thank you. My question is just, what does it look like to be a trainee? Is that a short defined period of time, or are there stipulations or any parameters around that?
By law, it is a 6-month license, in order for you to get the training and experience in order to pass both the written and the practical hearing aid dispensing exam to get your hearing aid dispenser's license. It can be extended twice, so up to 18 months, which you have to pass the written by the 12th month. And so there's some caveats, but it is a temporary license, and it's meant to be short term, and it is often supervised by hearing aid dispensers, but I do have audiologists that supervise many of the trainees as well. And then we've also, what was I going to say? There's a provision that if they fail the exam and they can't seem to pass it, they can keep trying to take it. And then I think after 3 years, they can come back and try again and be a trainee again after 3 years.
Did we create a limit on the number of times I could take the test? I know we talked about that,
Not
but I
yet.
don't remember us ever actually doing a
No.
limit.
And during that time where they can't operate as a trainee, they could continue to keep trying to take the exam.
Right.
They just can't operate. And usually that's where people start to fall off and we don't see them anymore.
Meaning because they're 100% supervision.
Well, no, they can't dispense hearing aids because they're no longer a trainee.
Oh, once they're not a trainee.
Yeah.
Oh,
once
I'm
they're
sorry.
no longer
I was thinking you
Yeah.
were saying when they failed the test.
Oh, no.
Then-
Once-
oh, gotcha.
it's
Right,
different,
right.
yeah.
Once they're outside the 18 months.
Once they're outside the 18 months, they can no longer dispense hearing aids. I do see sometimes where they failed, the trainee license is, they've already gotten their full 18 months. They now become an office manager, but they don't get to do any of the hearing aid dispensing at that office anymore. So, and then 3 years later, ta-da, we see them again.
3 years.
and they
out.
tried. But I can't remember, but I think that you could only do it that 2 times, right? I can't remember. I don't quote me on that one.
And Dr. Chambers, the typical length of time of a trainee is about a year. That's about average between them being able to pass the written test and pass the practical exam. So most trainees have their license for about a year before they get their permanent license.
Okay, thank you for that clarification.
So I think if the committee wants to, we can dive, I want to at least have this conversation so that we can answer your question and then also come back to staff and say, hey, we got to clean this up here. Like, while this says any licensee, only hearing aid dispensers can open a branch. They're the only ones that are going to independently operate and manage however
Right. And again,
we want to define that. We need to figure that one out as well.
Right.
that could be the next time as we start diving into some of this, along with, we're going to come back with the supervision language soon enough. So that when we look at all of that, we can be having those conversations and trying to tighten up a lot of this language. But to the extent that we can clarify and put in sunset some of these statutes that need to be like, hey, this only applies to the hearing aid dispenser, or yes, this applies to everyone. That way we can recommend those kind of technical changes for the sunset committee.
Okay, any other questions about the particular agenda item? Comments? If we could open up for comment, please, for public.
We are open for public comment via WebEx on agenda item 4. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take a few seconds now to see if we have a request for public comment. Seeing no request for public comment, do you wish to continue with the agenda?
Please. Okay, well, I believe that is the last item on our agenda. We will adjourn at 1:57. Thank you all very much. I enjoyed a good conversation about things.